How do lease agreements define property damage liability? Imagine renting a space and wondering who is responsible if something gets broken or damaged. It's a common concern, especially in business settings. Lease agreements are the key to answering that question. They are contracts between landlords and tenants that spell out what each party is responsible for regarding the property. When it comes to property damage liability, these agreements specify who must pay for repairs if the property is harmed beyond normal wear and tear. Property damage liability in a lease refers to the legal responsibility for fixing or paying for damage caused to the property. The lease will clearly state whether the tenant, the landlord, or both are responsible for different types of damage. This helps manage risks for everyone involved, especially in commercial leases where damages can be costly. Normal wear and tear is damage that happens naturally over time from regular use. For example, minor scuffs on walls or faded paint. Tenants are generally not liable for this kind of deterioration. Damage, however, refers to harm caused by misuse, neglect, or accidents. For instance, a broken window from a storm or water damage from a burst pipe. These are damages that go beyond what is expected from normal use. Lease agreements usually include specific language about damage. They specify who must repair or pay for damage caused by the tenant or their guests. They also distinguish between damage caused by the tenant and damage from external events like natural disasters. The lease will outline how damage should be reported and documented, including timelines for notifying the landlord and completing repairs. If either party fails to meet these obligations, consequences such as deductions from security deposits or legal action may follow. Tenants are responsible for damage caused by themselves or their guests, whether accidental or intentional. This includes broken windows, holes in walls, water damage from overflows, or fire damage caused by negligence. The lease might requiring tenants to carry insurance, such as commercial general liability insurance, to cover these risks. Landlords are generally responsible for maintaining the structural parts of the building and systems like plumbing and electrical wiring. They also handle repairs caused by external events outside the tenant's control. However, some leases may shift certain responsibilities to tenants, especially in commercial arrangements. Many tenants carry insurance that covers damage to the rented premises. This insurance often includes coverage for accidental damage like fires or storms. The lease will usually requiring proof of this insurance and specify minimum coverage amounts. At the start of a lease, both parties often document the property's condition with photos or written inventories. This helps prevent disputes about whether damage existed before the tenant moved in. If damage occurs during the lease, the agreement should specify how it will be assessed, who will pay, and how disagreements will be resolved. If there is a disagreement over responsibility for damage, the lease may requiring mediation or arbitration before taking legal action. Courts tend to enforce lease terms, so clear and precise language is very important. From a business law perspective, clear lease terms help reduce legal risks and conflicts. Businesses should carefully review lease agreements, negotiate terms where possible, and understand their insurance obligations. Landlords should draft leases that clearly allocate risks, and tenants should seek to limit their liability to damage they actually cause. In short, lease agreements define property damage liability by clearly stating who is responsible for different types of damage, how to report and repair damage, and often requiring insurance coverage. These provisions help manage risks and prevent costly disputes in commercial property rentals.